Hey everyone, my name is Nisha Ajmani. I'm a staff attorney at Housing and Economic Rights Advocates, and Daniel Alper is here too, who's also a staff attorney. He'll introduce himself after. I work primarily with tenants who deal with a range of kind of landlord-tenant issues, but then also credit and debt issues. So a lot of my clients have some sort of medical debt issue or credit card debt. So yeah, today we're going to talk about medical debt primarily, but our office helps folks with a lot of other types of debt as well.
Yes, good morning, folks. My name is Daniel Alper. I'm a staff attorney as well at Housing and Economic Rights Advocates. I focus mainly on home preservation and foreclosure prevention. I also do some work in debt collection defense as well, helping folks when they are facing collection actions. And I've not assisted with medical debt collection before, but some of the issues that come up in medical debt collection cases are similar to debt collection cases across the board. And so we'll be talking about some of those issues that come up later in the presentation.
Okay, so here's our agenda for today. Also, if you have questions, you're welcome to put them in the chat box, and we might be able to answer some questions as we go, but we'll definitely also save time at the end for questions, and just make sure to keep them, make sure that your questions aren't super specific to maybe a situation you or somebody else is going through, like a client, because we can't answer kind of very specific questions, and we want to be mindful about confidentiality. But we do have our contact information at the end. So if you want to refer someone to us for a more in-depth conversation, you're welcome to call Hera. Okay, so first we're going to talk about general information about medical debt. Then we'll provide an overview of options to resolve medical debt issues. We'll discuss an issue called surprise billing, which is thankfully has been mostly resolved in California through legislation. Then we'll talk about hospital financial assistance programs. The main assistance program is called Charity Care. We'll talk a little bit about veterans' kind of rights and options in regards to medical debt. We'll talk a little bit about immigrants and medical debt, then COVID-19 related issues and medical debt. Then we'll get into kind of more general information about the debt collection process and provide additional resources. And then we'll leave it open to questions at the end. Okay, so here's just kind of some general statistics about medical debt. All right, okay, there we go. So medical debt is a pretty significant issue in the US. According to an October 2021 Forbes article, 50% of Americans are burdened by medical debt. And of that 50%, 57% of the survey respondents owed at least $1,000 in medical debt. In total, debt collection companies in America held approximately $140 billion in medical debt for the year 2020. And between 2009 and 2020, medical debt was the largest source of debt Americans owed to collection companies. Medical debt burden and lack of insurance is disproportionately impacts people of color, which is probably not a surprise to all of you. In 2019, it was estimated that veterans owed approximately $1 billion in medical debt. And more than half of individuals who contracted COVID-19 or lost income because of the pandemic are struggling to pay their medical bills. And you can find more information at these sources down here on the bottom. So here's an overview of medical debt options. For recent medical debt, you just definitely want to make sure to check all of your medical bills and notices and keep all your mail and emails. I know some insurance companies will have an online portal, so you want to make sure to check that regularly. And if you're insured, check for balance billing. So what balance billing is the difference between the total charge for the treatment you received and the amount your insurance covers. So let's say the total charge, I'm just going to use an easy example, was $100 and your insurance covers $50, then you would be responsible for the remaining $50. And then you'll want to check to see if you qualify for financial assistance through charity care, which we'll talk about later, and the Veterans Affairs Administration has some financial assistance options as well. And if you're uninsured, you want to try to sign up for retroactive coverage. You can check to see if you qualify for charity care. You'd want to check to see if you would qualify for the VA health plan. And then you'd want to check to see if you'd qualify for local county health plan or some other government health plan. So you want to definitely make sure you check your billing and look for any mistakes or inaccuracies. So it's estimated that between 30 and 40% of medical bills contain mistakes. And then here are some steps that you can take to check your medical bills. You'll want to ask for an itemized copy of the bill, see if there are any items that sound like services you did not receive. And if only medical codes are provided, you can look up the codes to see if they sound like services you received. And then here's a link to a guide that can help you look up those codes. And then you'll want to check to see if there were any services you had to receive because of a hospital error. And then you can try to dispute that charge. So maybe the hospital made a mistake and that mistake caused you to need to receive another service, which you wouldn't have needed without the mistake. So you would want to try to dispute that if you get charged for it. Just some more information about medical debt and how it might, what issues might come up. So this is kind of an old statistic from 2016. So it's probably higher, I imagine now, especially with COVID, but 26% of households had problems paying or an inability to pay medical bills in a 2016 Kaiser survey. A common scenario is an uninsured or underinsured patient goes to an emergency room for treatment and later gets a bill for thousands of dollars. Most of the time, hospitals don't inform patients of available financial assistance programs, even though they're required to inform patients of these programs. Unpaid hospital bills end up going to collection agencies and eventually debt collection lawsuits. Definitely want to look out for common medical debt collectors, which are Rash Curtis and USCB America. Can also show up on people's credit reports. So it's definitely something to look out for. Okay, so now I'll talk a little bit about surprise billing. Thankfully, in California, this shouldn't be an issue anymore because of legislation, but beginning in July 2017, California law began to limit the surprise medical bills that patients received when treated by an out-of-network provider at an in-network health care facility. So essentially what that would look like is, if you look at this example down here, a consumer had a surgery at a hospital or an outpatient surgery center in their health plan network, but the anesthesiologist or some other healthcare worker was not in their health plan network. And so even though the consumer did not have a choice in who the anesthesiologist was, that provider would send a bill to the consumer after the surgery. So that's called a surprise bill. So a lot of consumers were receiving these surprise bills, believing they were being covered, that the treatment was all within their network, but being surprised to later learn that one of the providers was not in their health insurance network. So that can't happen anymore in California due to a law that was passed in 2017, and then also in 2020 at the federal level, Congress passed a bill eliminating surprise billing as well, and that took effect for health plans beginning January. For health plans that begin January 1st, 2022 or later. So consumers who go to an in-network facility now only have to pay for in-network cost sharing, which could look like copays, co-insurance, or deductibles. Okay, and then if you do end up having a surprise billing issue, recommend going to healthhelp.ca.gov, or you can call this number down here, 888-466-2219. Okay, so now I'm going to talk a little bit more about charity care, which is a law that says hospitals must have a discount financial assistance program available for uninsured or underinsured patients with high medical costs who are at or below 400% of the federal poverty level. So there's a way that folks can check to see if their household income qualifies. So you go to this website and there's a calculator, and then you'd enter the household income and then the number of people who live in the household. So what sometimes people who are eligible for charity care can get their medical debt completely eliminated or reduced and have some sort of payment plan. So under charity care, hospitals cannot charge more than the highest amount charted by government-sponsored health programs in which it participates. So for example, if the hospital participates in Medi-Cal, it can't charge someone who qualifies for charity care higher than the amount that that the hospital would be able to charge for a Medi-Cal patient. I hope that makes sense. So in general, a debt collector cannot report negative information to credit bureaus or begin a lawsuit against a patient for non-payment until 150 days after the initial billing. And failure to comply with the charity care law can be raised as an affirmative defense in a debt collection lawsuit. So that means that if someone gets sued for medical debt and they were never informed of charity care when they went to the hospital, but they were eligible for it, the charity care law can be raised as essentially a legal reason why the consumer should win the lawsuit. Okay, so a bit more about charity care. Hospitals must have a policy. On this website, you can search charity care policies by county. So all of the hospitals will show up with their charity care policies, which you can click on. So in addition to being at or below 400% of the federal poverty level, the cost of the person's medical needs must be high, and I'll get into what that means later. But even if somebody qualifies, let's say, based on their income, it's possible that they still wouldn't qualify in general for charity care if their medical costs aren't high enough. Okay, so which hospitals does charity care cover? A hospital means a facility that is required to be licensed under this law. except for a facility operated by the State Department of Hospitals or the prison system. It includes general acute care hospitals, acute psychiatric hospitals, and special hospitals. It does not include skilled nursing facilities, intermediate care facilities, treatment centers, or hospice facilities. And the law is here, Health and Safety Code, Section 127-400. Hospitals must inform patients of their possible eligibility for charity care at the time of the visit. But as I mentioned earlier, most of the time consumers are not informed about this possibility that they may be eligible for charity care, and find out later when they come to, work with HERA or another organization that can help with medical debt. So who is covered under high medical costs? High medical costs means any of the following: annual out-of-pocket costs incurred by the individual at the hospital that exceed 10% of the patient's family income in the prior 12 months. Annual out-of-pocket expenses that exceed 10% of the patient's family income if the patient provides documentation of the medical expenses paid by the patient or the patient's family in the prior 12 months. Or a lower level determined by the hospital in accordance with their charity care policy. So you want to look at their charity care policy to see what qualifications, if they have any different qualifications for high medical costs. And when somebody applies for charity care, they have to provide some documentation of their income, and it's limited to tax returns and pay stubs in terms of what to provide to prove income. And the time for applying eligibility for charity care may be determined at any time that the hospital is in receipt of the income information. Unfortunately, also with this issue down here, a lot of hospitals' charity care policies don't follow this law. So they'll say that somebody applied too late, too long after they received services, which is not, it's not consistent with this law and what's required. So people can be determined to qualify for charity care at any time. Okay, so more information about discounted payment plans and who would qualify and what the rates would look like. The hospital can't charge more than it would expect in good faith to receive for providing services from government-sponsored health plans, like I mentioned before. So for example, Medicare, Medi-Cal, the Healthy Families Program, or another government-sponsored health program in which the hospital participates. So an extended payment plan, the charity care policy must include an option for an extended payment plan to allow payment of the discounted price over time. At a minimum, a reasonable payment plan under the discounted policy is one where monthly payments are less than 10% of a patient's family income for a month. And family income does not include essential living expenses. Extended payment plans must also be interest-free. So now I'll talk a little bit about, well, actually, Leah, if I could back up and do the first poll question. Okay, so the correct answer is D, B, and C. So folks can submit their tax returns and pay stubs to be considered for charity care. Okay, and can we do the second poll question? Okay, so the correct answer is C, at any time. Okay, so now I'll talk a little bit more about Veterans Affairs health benefits. folks may be eligible for the Veterans Affairs Department health insurance plan. There's currently a bill in Congress which would automatically enroll eligible veterans in the VA health plan. I tried to find kind of an updated status on that bill and wasn't able to. So it's possible it might have passed already, but I wasn't able to find more specific information. So the eligibility requirements to be in the VA health plan, it's if folks have enlisted after September 7th, 1980, or entered active duty after October 16th, 1981, you must have served 24 months continuously or the full period for which you are called to active duty, unless any of the following are true. The veteran was discharged for a disability that was caused or made worse by active duty service, or you were discharged for hardship or early out. You served prior to September 7th, 1980. And if you're a current or former member of the Reserves or National Guard, you must have been called to active duty by a federal order and completed the full period for which you're called. If you had or have active duty status for training purposes only, unfortunately, that does not qualify a veteran for health care under the VA health plan. And then, unfortunately, other than honorable bad conduct or dishonorable discharge may disqualify someone from the VA health plan, but folks can apply to upgrade their discharge status at this website down here, va.gov/healthcare eligibility. There are also legal organizations that can help folks try to upgrade their discharge status. So I think one in the Bay Area is called Swords to Plowshares, but that's definitely an option to try to get qualified for the VA health plan. So some more information about medical debt, financial assistance options under the VA health plan. A few main options include requesting a monthly repayment plan for medical debt, requesting a copay exemption if the veteran's gross household income has decreased. They may be eligible for a copay exemption, so meaning they wouldn't have to pay copays. Or veterans can request a waiver or deduction in the total medical debt owed. They must provide a written statement describing why they are requesting a waiver. So for example, I lost a job, and then you have a right to a hearing under this third option. And then, so for more information about how to apply for financial assistance with the VA health plan, you can go to this website here. And under the American Rescue Plan from 2020 to 2021, unfortunately, this isn't in effect anymore, but co-payments for medical care and pharmacy services provided by the VA from April 6th, 2020 through September 30th, 2021 were canceled. However, if you did have to pay a co-payment for health services by the VA during this time, or pharmacy services, veterans should have received a refund. So if folks believe that they should have been eligible for this refund and didn't receive it, they can click on this link up here or call the VA Health Center at 866-400-1238. So here's some more information about how folks can find their credit report online, or you can request it by mail. And so checking your credit report is really helpful to see if there's any medical debt that shows up on your credit report. So for example, as I mentioned earlier, Rash Curtis is one, and is one debt collector that we see often, and then also USCB America for medical debt issues. So you would want to go to annualcreditreport.com. This is the only website you should go to. I'm pretty sure most of the other websites are scams, so definitely go to this website, annualcreditreport.com. And then you'd have to enter your information. Then you'd want to check that you want TransUnion, Equifax, and Experian, so all three major credit reporting agencies. And then you would be able to download your credit reports, but you can also request your credit report by mail using this mail request form, which you should be able to find on the annualcreditreport.com website. And if you can't find it, definitely recommend calling them, their phone number. I think there's a phone number on this form, but if not, then go to the contact us on the annualcreditreport.com website. And if you have an ITIN number, folks must request their credit report by mail. So now I'll talk a little bit about immigrants and medical debt options. Medical debt in the US disproportionately impacts people of color. It's common for undocumented immigrants to delay seeking healthcare because they're unable to provide insurance documents. In California, there have been efforts to increase medical assistance and treatment for undocumented immigrants. So in July 2021, Governor Newsom signed a bill that expanded full scope Medi-Cal to low-income undocumented Californians 50 and older. Prior to that, low-income young adults in California under the age of 26 who are undocumented have been eligible for full scope Medi-Cal. So this law for undocumented folks in California under the age 26, they have been eligible for full scope Medi-Cal for quite a while. And then in January 2022, Governor Newsom proposed to expand Medi-Cal eligibility to all low-income Californians, regardless of immigration status and age. So right now, adults between 26 and 49 don't have full scope Medi-Cal or aren't eligible for full scope Medi-Cal. Here's some more information down here about where you can find information about medical debt and immigrants. Okay. So I think now this is Daniel's slide. I will mute.
Thank you so much, Nisha. Medical debt is a very common type of debt on credit reports. In the United States, about 20% of households have medical debt on their credit reports, and about 58% of those bills are in collections. And so it's important, if medical debt shows up on the credit report, that if the patient is concerned about it, does not agree with the amount, or doesn't recognize it, that it gets disputed. And so the first step in that process would be to obtain a copy of the credit report. As Nisha mentioned, you can obtain a copy of the credit report on annualcreditreport.com. That is the best site to go to. Other sites are questionable. So annualcreditreport.com for an online copy, and then you can also request a copy of the credit report by mail. Of course, obtaining it online would be faster, so that's likely preferable. And so common debt collectors, again, for medical debt, Rash Curtis and USCB America, they're common medical debt collectors. The debt collectors are the ones that are reporting the debt to the credit reporting agency if in fact the debt has been sold. We'll talk about that process, how the debt eventually gets sold to debt collectors in a little bit. But anyhow, so if the patient doesn't recognize the medical debt account or doesn't recognize the amounts that are claimed as delinquent, or if the patient wasn't informed of charity care, then it can be disputed. And so it can be disputed by either sending a letter directly to the debt collector. It can be a debt validation letter. Again, I'll talk a little bit more about debt validation letters in a little bit. Or the patient can file a dispute directly with the credit reporting agencies, a Fair Credit Reporting Act dispute letter. That is something that HERA does help folks with as well. credit report dispute letters. And there's more information about just the general issues with medical debt in the United States here on this link at the bottom of the slide. And the slides will be provided after the presentation. Okay, so there are a few programs that are available to help folks with COVID-19 related medical debt. First of all, there's the COVID-19 Uninsured Group Program. This was created by the Department of Healthcare Services. And essentially, this provides temporary free COVID-19 related care for either uninsured or underinsured California residents. So if the patient is uninsured or the insurance does not cover COVID-19 related care completely, then the patient may apply for this program. In order to be eligible, the patient must live in California. There is no income or resource maximum. There's also no immigration or citizenship requirement, but the applicant may be required to provide a social security number if they have one. So just keep that in mind. And the citizenship and immigration status also, it may be verified, but again, that's not a condition for eligibility for the coverage. What is the time frame of the coverage? It begins on the date of the application and lasts for 12 months or until the end of the pandemic, whichever is first. And the coverage is also available retroactively back to April 8th of 2020, which is very helpful. And so the free coverage that's provided by the COVID-19 Uninsured Group Program, it covers testing and testing related services, treatment, as well as emergency room, hospitalization, and hospital stays related to COVID-19. For more information about this program and how to apply, you can check out the link here, healthconsumer.org, at the bottom of this slide here. And to apply, the patient needs to go through the nearest qualified Medi-Cal provider, and the phone number to find the nearest qualified provider is available on that link there at the bottom of the slide. And they do provide translation services as well. Okay, a couple more programs that are available. Under the Families First Coronavirus Response Act, the federal government's share of Medicaid costs is increased. And so states that accept those increased federal funds are required to maintain their efforts to keep folks enrolled in Medicaid or Medicare, and can't cut coverage while the federal funding increase is in place. So this is very helpful because this ensures that patients remain insured, and ensures that folks who have change in circumstances aren't required to submit a whole bunch of documentation or respond to communications in order to maintain their coverage. A lot of the time when folks have to be reviewed for their eligibility, sometimes they don't respond or they don't provide the necessary documentation and they lose their coverage. And so the Families First Coronavirus Response Act effectively prevents folks from losing their coverage when they live in a state that's accepted this additional federal funding. And it also requires health plans, whether private or public, to pay 100% of the cost for testing of patients. In addition, there is the Health Resources and Services Administration. It's a federal agency. It allows healthcare providers to bill the federal government under a provision of the CARES Act, the Coronavirus Aid Relief Act that was passed when the emergency was declared. And essentially, this allows for healthcare providers to bill the federal government for COVID tests if patients are uninsured. This program is subject to the availability of funding. So when the funding runs out, uninsured patients will be required to pay the full cost of COVID tests. I did look this up. I did not see that the funding had run out. Nisha, if you know something different, please feel free to chime in, but that's what I found when I looked this up, is that it does not appear that the funding has run out for this program.
Yeah, I think that's correct.
Thank you. Okay, so here is a sort of general timeline of debt collection. This applies to all sorts of debts, not just medical debt. So its application may be a little bit broader than this workshop. Okay, so what happens first? The borrower falls behind on their payments, and in this case, it's not a borrower, pardon, it's a patient. But in normal or in other debt circumstances, pardon, it would be the borrower. So on a credit card or an installment loan, an auto loan, whatever the debt is, falling behind, failing to make a payment. Now, in some instances, for the consumer, this may be strategic. So some debts have a more immediate risk of loss. A debt collector or an original creditor, the hospital, for example, can't just take the consumer's money if they fail to make the payment. They have to go through the legal process. So ultimately, if a hospital sells the debt to a third party, the debt collector would have to file a lawsuit and obtain a judgment against the consumer in order to collect that debt. By contrast, debts that are secured, for example, mortgages and auto loans, they can have a much faster loss that is associated with falling behind, where the debt is secured by the vehicle or the home, and falling behind on those payments can result in a loss of that asset, which can be extremely harmful to the consumer. So sometimes it's strategic not to make a payment on one debt when someone is financially struggling in order to preserve important assets like the home or the family vehicle or what have you. And so that's just something to consider when folks are struggling financially, trying to decide what debt should I pay. Sometimes it makes more sense to pay those secured debts and allow those unsecured debts to fall behind if there's no other option there, because of the immediacy of the risk of loss. Again, if there's an unsecured debt like medical debt, for example, the debt collector or the original creditor, in this case the hospital, would actually have to sue and obtain a judgment before they could actually collect the consumers. Okay, so after falling behind happens, the lender, in this case the hospital or the provider, reports the debt as a loss for accounting purposes after 120 to 180 days, depending on the type of debt. And so on a credit report, this will often appear as a charge off. So it'll say charge off on the credit report. Keep in mind that charge off does not mean that the debt is no longer going to be collected or that it's uncollectible. It simply means that it's been written off as a loss by the creditor. So folks, sometimes I've seen folks that have a charge off on their credit report and they think, oh, that means I don't have to pay it. And that might not be the case. It may still be collectible and may still subject the consumer to further collection activity. In any case, if the debt is charged off, the borrower is still technically liable for it. Okay, so after that happens, the debt is charged off. Often the debt is sold to a debt buyer. again, in the medical debt context, it might be Rush Curtis or USCB. Those are common collectors in the medical debt context. And so typically the debt is sold for pennies on the dollar. It's not sold for the full amount of the debt. The debt buyer will then make attempts to collect on the debt. Often they'll send collection letters to the consumer demanding payment. The consumer does have rights in terms of demanding certain documents from the collector to show that the collector has the right to collect the debt. Talk a little bit more about debt validation letters moving forward. But again, keep in mind that at this stage of the game, when the debt collector starts sending collection letters to the consumer saying, okay, we own this debt, it's time to pay, the debt collector does not have the right to obtain the client's money. They can't just reach into the client's bank account or garnish their wages. They would have to obtain a judgment before any of that can happen. Okay, so if the debt goes unpaid, actually just a little bit more on receiving those collection letters I would like to point out. If the debtor does not dispute the debt and would like to settle the debt, then they could certainly do that if that's their wish. Keep in mind that there are a statute of limitations, time limits for these actions to be brought. In California, there's a 4-year statute of limitations on a written contract. So it's 4 years from the date of the last payment in the collection context, where the lawsuit must be brought, or otherwise it is time barred. So 4 years from the date of the last payment for a written contract, 2 years for an oral contract. And so if the consumer affirms the debt and sends some sort of writing to the debt collector saying, yes, I agree, I owe this debt, that can restart the statute of limitations. So it's important that if the consumer is going to make efforts to settle, even if it's outside of the statute of limitations, that might not necessarily be advisable. But in any case, it would be a good idea not to say outright, I do not dispute this debt, I agree that I owe it, because that could restart the statute of limitations and drastically affect the consumer's right to raise the statute of limitations as defense. And so I would just suggest that if a consumer would like to settle, that they include a statement that they do not necessarily agree that they owe that amount, but that they would like to settle the matter. And of course, label that correspondence as a confidential offer for settlement as well.
Daniel,
okay.
can I ask a quick question? Actually, this has come up for some of my clients. Let's say that the statute of limitations has passed, but with a credit reporting, delinquencies can show up on the credit report for 7 years. So let's say a statute of limitations has passed on a debt and the consumer doesn't dispute that they owe the debt. So let's say, it's been 5 years since the last payment, but it's showing up on the credit report for 2 more years. If they want to try to pay something to get it deleted from their credit report, can they make a proposal and then just say, include a statement saying, I don't agree that I owe this debt, but I want to try to, resolve it and get it deleted from my credit report? Is there a way that they can kind of try to negotiate to at least get it off their credit report?
I think that sounds like a reasonable approach. I think that the most important thing there would be to not make a statement that the debt is affirmed, because if the debtor makes an affirmation of the debt, essentially ratifying it, then that restarts the statute of limitations all over again. But it may not if it's already outside of the statute of limitations, if the statute of limitations has already run. I would need to look at that again, but I do recall seeing that if it's already outside of the statute of limitations, then that rule may not apply, that it re-triggers. But in any case, just to be on the safest side, I would just not affirm the debt if that's the effort to get it off the credit report. I would just have the correspondent say, I do not agree with this debt, but I would like to get it off of my credit report and settle them.
That makes sense. Okay, thank you.
Okay, sure. Thank you. Okay. All right. So another issue to keep in mind in terms of statute of limitations. So a lot of new laws were created as a result of the COVID-19 emergency. One of them to keep in mind in this context is COVID-19 Emergency Rule 9. And that is the COVID-19 emergency rules were created by the Judicial Council in response to the COVID-19 emergency. This rule essentially extends the statute of limitation, which ran between April 6th of 2020 to October 1st of 2020. I don't know why that says 2021. My apologies. That is not correct. And I made this slide, so my sincere apologies for that. It's April 6th, 2020 to October 1st, 2020, 178 days. And so as a result of this rule, any statute of limitation that would have ran down during that time period is extended for 178 days from the day when the statute would have run. And so it's a pretty broad rule. So for example, let's say that a consumer made their last payment on a debt on April 1st of 2020. Well, the emergency rule would apply because the statute of limitation for that debt began to run as of April 1st, 2020, which would include this 178-day period from April 6th till October 1st of 2020. And the time limit for a debt collector to bring a collection action would therefore be extended by this period of time during which the statutes of limitation were told. And so this effectively gives creditors and debt collectors additional time with which to bring an action to collect the debt, and affects consumers' rights to the defense under the statute of limitations. Because the statute is extended, the availability of the defense is limited in that way. And so it's just something to keep in mind for folks who are facing collection in terms of the availability of the statute of limitations defense. And so after the complaint is filed, it's very important to respond in a timely fashion. Once the defendant, that's the name of the person who gets sued, once the defendant receives service of the complaint, it's done in person, so the defendant will be personally served. The defendant has 30 days to file their answer. We see a lot of folks who do not respond to these complaints in time, and what that can result in is a very unfortunate default judgment, meaning that the debt collector doesn't even have to prove that they have the right to collect the debt. They just win by default because the defendant did not answer the lawsuit. And so it's very important to preserve the consumer's rights to defend the lawsuit and dispute the debt by filing that answer in a timely fashion. And so again, the answer has to be filed and served within 30 days of the service of the complaint. And this is of course an area that HERA offers assistance in, debt collection defense. And so folks can always come to HERA if they've been served with a debt collection lawsuit. Certainly something that we could advise. Okay, so the complaint is served, the answer hopefully gets filed in time, the lawsuit progresses. Sometimes debt collectors will, if the lawsuit is defended, if an answer is filed and the consumer follows up with discovery requests, essentially requests for information, asking the debt collector to show that they have the right to collect the debt. For example, the assignment of the debt from the original creditor to the debt collector, showing that that particular account was actually sold from the original creditor to the debt collector. If the debt collector doesn't have that information, then essentially they would not be able to win at trial. And often we see that debt collectors will dismiss the case if the consumer raises that as an issue. And that's something that the debt collector itself must prove. The debt collector must prove that they have the right to collect the debt with valid written evidence of an assignment. Without that key evidence, the debt collector cannot win. If the lawsuit is successful on the plaintiff's side, the debt collector succeeds in obtaining a judgment, then the consumer still has rights to prevent the collection of that judgment. Someone might be judgment-proof, meaning that all of their assets and resources are protected by law, whether that's because all of their resources come from some sort of protected government benefit like Social Security, or all of their resources are absolutely necessary for the care of the consumer and their family. Then the debt collector may be the debtor, may be judgment-proof. And at that point, it would be a good idea to send a judgment-proof letter to the judgment creditor. That's what we call the entity or the person that obtained a judgment creditor. It's a good idea to send a letter to the judgment creditor saying, hey, I'm judgment proof, all of my assets and resources are protected by law, you cannot collect them, please do not proceed with any further collection activity. That would be, it is considered an abusive process for a judgment creditor to proceed with collection activity when they know that the debtor is absolutely judgment proof. If the judgment debtor wants to dispute the judgment creditor's right to collect on the debt, whether through a garnishment or bank account levy, or a lien on the property that can be executed with a foreclosure sale, then the debtor needs to file a claim of exemption. A claim of exemption is a form which explains what assets and resources the debtor has that are protected by law that cannot be subject to collection. There's also, for example, a homestead exemption. A certain amount of the equity in a homeowner's principal residence is protected as well. And so if any of those exemptions apply, it's important to file the claim of exemption within 15 days of receipt of the notice, the date on the notice. File the claim of exemption within 15 days of the date that's on the notice that the debtor's assets are going to be levied or garnished. And that way the debtor preserves their right to dispute any further collection activity with respect to those protected resources. Okay, and at this point, let's do polling question number 4. The time limit to file a claim of exemption is 15 days after the date on the notice of the levy or garnishment. And so again, it's important to make sure that that is filed within that 15-day time limit, because the right to dispute the garnishment or levy can be lost. However, even if the debtor does not file the claim of exemption within that time frame, we would still advise them to file it, just in case. If the judgment creditor does not dispute the claim of exemption, then it may still be considered valid and upheld. And so even though there is that 15-day time limit, we would advise that folks send it in regardless. All right. Moving on here. So when a consumer receives contact from a debt collector attempting to collect the debt, the consumer has the right to dispute it and to demand that the debt collector validate that they have the right to collect the debt and to explain the debt itself. It's important for the consumer to know that the debt collector actually has the right to collect the debt, that they can show the documents that demonstrate that they have that right. Again, evidence of an assignment in writing, and not just that the original creditor sold some accounts to the debt collector, the debt collector. We see that as well, where a debt collector may have documentation showing that they purchased some accounts from the original creditor, but in order to be able to succeed in a lawsuit, the debt collector would need to show not just that they purchased some accounts from the original creditor, but the specific account that they are attempting to collect on. And so it's important to obtain that information. Also, it's important to find out when the date of the last payment was made in order to understand how the statute of limitations is where the consumer is at in terms of the statute of limitations timeframe. And so it's important to ask that information. So here's just a general lineup of the information that it's important to ask for: what the debt was for, who the debt collector is, all of their contact information, the amount of the debt, any fees that were added onto it, like interest or collection costs, late fees, what have you, the account number for the debt, so that the consumer can confirm that it was in fact their account that the debt collector is attempting to collect on. Also, the contact information for the original creditor, again, so that the consumer can verify that they actually incurred this debt, and that they can be obligated to pay it. Documents showing that the consumer is liable, for example, a copy of the last bill, information about whether you or someone else may owe debt, whether the services were actually incurred in the context of medical debt, whether those services actually were provided, the date of the services or the date that the debt was incurred, when the account became delinquent, so at what point the consumer or the patient stopped making payments on the debt, when the debt collector obtained the debt, and what amount was owed on the debt at the time that the debt collector purchased the account. This is all information that should be requested in writing in a debt validation letter. Anytime that a consumer corresponds with a debt collector, it's important to maintain records of the correspondence. I would suggest sending it certified mail with a return receipt requested, so there's just absolutely no question that it was received. You have that tracking information, and it just creates a good paper trail that that this step in the process was done. Okay, again, dealing with debt collectors, sometimes folks will get phone calls. They can be incredibly frustrating to get repeat phone calls from debt collectors. When a debt collector calls and is attempting to collect a debt, my sort of general approach to it is that the person who receives the call should not be providing a whole bunch of information to the debt collector. the debt collector should be providing information to the consumer. So don't give out sensitive information like social security numbers or bank account numbers, especially because there can be scams. The person who's calling may not actually have the right to collect the debt. They might not actually be a debt collector. They might be posing as one in an attempt to scare the consumer into providing sensitive information. So there's no obligation to provide social security numbers, bank account numbers, anything like that, no matter what they say. It's just all across the board important not to provide that information. Keep good records, keep everything that debt collectors send, all of those letters, records of the phone calls as well. Make a note, what time, what date, what was said, who called, who did they say that they were calling on behalf of, what debt did they say they were seeking to collect, etc. Also, check the mail. If a lawsuit is in progress and correspondence is not responded to, for example, discovery requests. If the consumer, now the defendant in a lawsuit, receives discovery requests for information about their position in the case, responses are due generally within 30 to 35 days, depending on how the documents are received. And so it's important to respond timely to those documents, and especially if the consumer is served with a lawsuit, personally served with the summons and the complaint, really important to file that answer within 30 days to avoid the dreaded default judgment. All right, next slide. And how to stop collection calls and notices. So you can tell the debt collector, or the consumer rather, can tell the debt collector that they do not want to be contacted. Or they can specify how they want to be contacted. So if the consumer is okay with receiving mail, but they don't want phone calls, they can make that request to the debt collector. The debt collector must comply with that request. So if that request is made, it's important to make it in writing, keep a record of that correspondence. And here are some sort of across the board unfair debt collection practices. If a debt collector engages in this kind of activity, it can give rise to a legal claim under the Federal Fair Debt Collection Practices Act, or potentially the state Rosenthal Fair Debt Collection Practices Act as well. And it might not be a defense to the lawsuit, but it can be an affirmative claim that the consumer can bring against the debt collector. So calling at inappropriate times of day before 8 a.m. Or after 9 p.m., that's not allowed. Harassing, so repeat phone calls over and over and over again, trying to harass the consumer into making a payment, that could be considered unfair debt collection. Threats, for example, threats of criminal prosecution. Thank goodness, failing to pay consumer debts is not a criminal issue. A person cannot be incarcerated for failing to pay a consumer debt. And so threats of prosecution or arrest or anything like that, unlawful threats with respect to the debt, that can be considered unfair, unlawful debt collection. Calling people who are not the debtor about the debt, there is a very narrow exception for this rule that has to do with obtaining the whereabouts of the debtor. So technically the debt collector could call the employer and simply ask for the location where they might be able to find the debtor, but that is a very narrow exception. And beyond that, calling a boss, friends and neighbors saying this person owes this debt, we want them to pay it, that would potentially be considered unlawful debt collection. Well, lying, falsehoods, that's considered unfair debt collection. Demanding more than what is owed, or adding unauthorized fees that are not authorized either by the contract or by law, that's also considered unfair debt collection. and can be legally actionable. So again, disputing the debt with a debt validation letter. Under federal law, the time limit to send this debt validation request is within 30 days after you receive that first collection notice. The debt collector does have to provide notice of the right to dispute the debt. Failure to provide the notice to the debtor that they have the right to submit this debt validation letter can also be a violation of the Fair Debt Collection Practices Act under federal law. And so it's important for this letter to be sent out within 30 days to preserve the debtor's rights to use this debt validation procedure. The debtor may lose the ability to dispute the claim if they wait to do this until after a court enters a judgment. Even if they do miss the 30-day period, though, we would still recommend sending the letter. If the consumer does send the debt validation letter within that first 30 days of the collection notice, the debt collector must provide the information that is requested. For example, the name of the original creditor, when the debt was charged off, what the balance of the debt was at the time that it was charged off, evidence of an assignment, so documents showing that the debt was sold from the creditor to the collector, etc. And so until the debt collector provides this information, they're not supposed to continue with collection efforts. The debt collector, after they tell the debtor about the right to dispute the debt with a debt validation letter, the collector can still keep going about their collection activity. It's not until they receive that debt validation letter that they have to stop, but until the collector provides the information that's requested in the debt validation letter. So it can be a powerful tool to shut off the collection activity using this debt validation letter procedure. Okay, so at this point, let's if you wouldn't mind bringing up full question number 5, please. Excellent. All right. So the correct answer is D, both A and B. If a debtor sends a debt validation letter to a debt collector disputing the debt within 30 days after receiving that collection notice, it's the first collection notice where the debt collector provides notice that the debtor has the right to dispute the debt. The debt collector must both provide the debtor with written verification of the debt and cease all collection efforts until it does so. So again, this debt validation letter procedure can be a very powerful tool in terms of stopping the collection activity until the debt collector provides the required information. Sometimes debt collectors do not have the information that they need in order to collect these debts. They can't prove that they have the right to collect. Okay, so under California law, if a debt buyer purchases the debt after January 1st in 2014, they have to have the following information. They have to have specific information and evidence of the debt before making any attempts to collect. The debt buyer must also explain in writing that the debtor has a right to obtain this information, and explain to them and explain to the debtor that they can ask for it. The debt buyer also has to provide copies of that information within 15 days of the request. This is under state law. Must provide the information within 15 days or stop collecting until it does provide that information. Also, the debt buyer must inform the debtor that they will not be sued if the debt is time barred. So if a debt is time barred, then the debt buyer must explain that they're not going to file a lawsuit. Failure to do so would potentially be legally actionable under the Fair Debt Buying Practices Act. Also, if the initial communication with the consumer is in English, then any legally required communications with the consumer must be in that same language. So protecting folks who may have language barrier issues. Okay, so sometimes folks come to us and they already have a judgment against them. Hopefully, folks have sought support when they first realize that they've been sued. Unfortunately, a lot of the time, folks get scared. Folks are nervous. Sometimes people are ashamed of being in debt, and so they don't reach out. And so if whatever the case is, if someone has a judgment against them, then there are still protections that are available. I mentioned a little bit before about claims of exemption. Claims of exemption must be filed within 15 days after the date on the notice of the garnishment or levy notice in order to preserve that right. For wage garnishment, just in general, no more than 25% of wages can be garnished in each pay period. If someone is a very low income or part-time wage earner, then 100% of their wages may be protected. Or if all the wages are needed to support oneself or dependents, then the wages that are necessary for support would be exempt. In terms of bank account levy, judgment creditors can't levy a bank account, can't take money out of the bank account if the source is protected by law. So if all of a person's funds in their bank account are from Social Security, for example, then those resources in the bank account would be exempt from a bank levy. Also, any funds in the account that are necessary for support of the debtor and their dependents, those are also exempt from collection. There's also a basic adequate standard of care for a family of four exemption. Currently, that's $1,736. And so that is that's per consumer, not per account. So each consumer has a right to keep $1,736 in their account, the basic adequate standard of care for a family of four. That number is subject to change. Currently, that's the figure though. Again, in order to take advantage of these protections, claim of exemption needs to be filed within 15 days of the notice. And if the debt collector or the judgment creditor disputes the claim of exemption, then the debtor may need to appear in court and for a debtor's examination in order to provide proof of their income and resources in order to validate the claim of exemption. Debt settlement companies, a lot of the time consumers will be contacted by debt settlement companies. It might not necessarily be a good idea to work with them. Often the services that they provide can be provided for free by nonprofit organizations such as HERA. Some debt settlement companies to look out for: Freedom Debt Relief and Lexington Law. They'll often charge expensive fees. Again, often these services can be free with nonprofits, so one reason not to go with the debt settlement companies. Creditors may refuse to work with them as well. They just might not respond to a debt settlement company. Sometimes the debt settlement companies will advise consumers just to stop paying their debts altogether, which can result in late fees, penalties, and other such charges accruing. If folks are really struggling, between putting food on the table and paying their debts, that might be an instance where we would advise, yeah, maybe it's better not to pay this debt if you need those resources for more immediate needs. But generally, just a blanket advisement to stop paying debts, that's generally not very good. Also, built up penalties and fees on unsettled debts can negate any savings that were achieved with the debt settlement company. And in some instances, debt settlement services can have a negative impact on the credit score. So just generally, debt settlement companies, they're there. It can be risky. We wouldn't necessarily advise. Here are some additional resources. HERA's website, the Alameda County Health Department, Covered California, Medi-Cal health insurance, and VA health benefits. All good resources to reach out to and explore to see if folks might be eligible for discounts or other programs that can help them to manage their obligations, and just to help them see what options are available to them. And let's see, let's do the last polling question. Charge off on a credit report does not mean the debt is no longer collectible. So the answer is false. If charge off appears on the credit report, all that means is that that particular debt was written off as a loss by the original creditor. Technically, the consumer is still liable. There may be other ways to dispute the debt. For example, using a debt validation letter, demonstrating that the debt collector doesn't have the document that they need to demonstrate the rights to collect the debt. But at that point in the timeline, charge off does not negate the consumer's liability. Right, and that is the end of the, we have this last slide here, just a brief explanation of the services that HERA provides. We provide services related to general debt and credit issues, student loans, auto loans, medical debt, of course, payday loans, HOA dues. One of the types of debt that I deal with is PACE loans, loans for energy efficient home improvements. We help folks with credit reporting, identity theft, disputing items on the credit report, or a denial of credit or a loan due to issues with the credit report. A financial product recommendation, so advising folks how to build credit, foreclosure prevention. Nisha does a lot of work in our tenant division, helping folks address pre-eviction concerns, fair housing complaints, habitability problems, dispute with the landlord, and also prep and debit issues related to housing. Veterans and service members enforce their special protections available under the law, special resources for veterans and service members that HERA can provide advice about, and also estate planning. Estate planning is a service that we provide on a sliding scale basis. All of our other services are free. So the estate planning service is provided based on a sliding scale, which is determined by income, status, and we help folks with their wills, trusts, advanced healthcare directives, and powers of attorney. And so if you know someone that needs HERA's support, please feel free to provide them with contact information. It's there below at the bottom of the slide.
I want to thank our presenters, Daniel and Nisha. Thanks so much for all the great information that you provided. Reminder to everyone to fill out your evaluation. I'll be sending that in your emails today. And I'll also be sending a resource link with the link to the recording and other resources as well. Thanks so much, everyone, for joining us. I hope you have a great day.